Yes. I'm John Ford. I'm an attorney with the legal aid program in Lynn at 181 Union Street. It's in the Walmart Mall. And I'm assuming that everybody here is either a caregiver or supporting a caregiver.
Yes.
So what we want to do today is, if you came here with any questions, we want to make sure you leave with the answers. So we have a PowerPoint presentation, which my colleague Ethan So put together. So what we're going to go over, you all have an outline of what we're going to be talking about. So we want to make sure we cover everything. But feel free to, if you have a question, feel free to sing it out and we'll try to answer it. Okay, any questions before we begin? Sure, sure.
Welcome, everyone. Good afternoon. Happy almost spring. I'm Crystal Polizzotti, the director of the Family Caregiver Support Program. This workshop today is made possible by a grant through AGE, the Aging Offices of Aging and Independent. Those are our state offices. They were formerly known as the Executive Offices of Elder Affairs. They rebranded. So thank you all for making time out of your busy schedules to be here. If you are enrolled in our program, there are some scholarships eligible through this. That's an offline discussion with Lynn or I. But if you're an active family caregiver, we're happy to explore that with you. So I'm going to let the experts take it away.
Okay, so this is the subject of today's discussion. Remember that I'm not giving you legal advice. This is all educational. Everybody has a unique situation, and I'm probably going to be recommending more than once today that it may be very advisable for you to consult with an expert, whether it's an attorney or a geriatric care manager or anybody who has expertise in the area that you have a question about. All right, let's go to the next. So that's the agenda. I've already introduced myself. We want to talk about the basic life planning documents. This is not only for the person you're taking care of, but for yourself. Everybody who's over 18 or over should have 3 basic documents: a healthcare proxy document, a durable power of attorney, and the last will and testament. And you might have a need for more than those documents, but those 3 are essential documents, and we'll explain why as we go. Oh, go back to caregiver issues, planning for nursing home placement, how Mass Health pays for nursing home costs, assisted living residents and continuing care retirement communities, Mass Health estate recovery, and questions and answers. Okay, so now let's go to the next one. I want to start by strongly recommending Mass Bar Association and the Mass Chapter of the National Academy of Elder Law Attorneys publishes a elder law education guide, and we have some copies for those of you who are lucky enough to get it.
I can print more. I just didn't want to overprint because it was 200 pages.
You can download it on Google if you just punch in the title. You can download the whole thing. It's kind of lengthy, 166 pages or so. But this really is a very valuable resource that really covers virtually every subject that a question may arise about. Those of you who can take one home will agree with me, I'm sure. If you don't get one, you can download it, as I said, easily enough from the Google. Yes, we're in the process of developing the 2026 version of the guide that ought to come out probably in April. They usually distribute it during Elder Law Month, which is in May of every year. Okay, next one. So, in my view, the most important document for you or your loved one to have is a healthcare proxy. A healthcare proxy document is an opportunity for you to designate somebody to make medical decisions for you if you're not able to do so. So if the person you're providing care for does not have a healthcare proxy document in place, that's the first thing you should strive for, is to get one signed, witnessed, and put in the medical records of the person that you're taking care of. For a lot of reasons, it's very valuable. One is you have an opportunity to name somebody who you know and trust to be responsible for making medical decisions if you're not able to make medical decisions for yourself. And that document gets activated when the healthcare proxy agent and the doctor who's treating the patient agree that the person no longer can give informed consent to treatment. Everybody here, if you're over 18, you have the right to accept or decline medical treatment. And in order for anybody to provide medical care, they have to get informed consent from you to provide that care. And informed consent means the patient understands the medical conditions that are being treated and the risks and the benefits of the treatment that's being recommended. And it's really, when I say 18 years old or older, I mean it. You don't have to wait until you're in your 60s to sign a healthcare proxy document. The case from the United States Supreme Court that dealt with the constitutional right to accept or refuse medical treatment is the Nancy Cruzan case, a woman in her 20s from New Jersey who was in an automobile accident. The oxygen supply to her brain was interrupted, so she was basically in a vegetative state. And the issue was whether the family could remove the life support systems, or did the state have the right to interfere with that? That case involved a Right to Life group that wasn't involved with abortion, but with the other stage of life, which is when somebody was being kept alive on life supports. And there was an organization that said that the state could prevent the family from disconnecting the life support system. So nobody wants to go through litigation when there was so much going on in your life. So a healthcare proxy document, everybody, I won't ask if anybody here has signed it. I'll just assume you have, but if you haven't, you definitely should. There is a website called Honoring Massachusetts Choices. It's all in the guide, but it actually can walk you through how to do your own healthcare proxy document. It has to be signed as witnessed by two people. It has to be, you have to be clear that that's what it is. The document is a healthcare proxy document, not a grocery list or any other document.
I signed them at the hospitals for both my families.
Most hospitals will require you to sign a healthcare proxy. If you go into a hospital and you have capacity to sign a healthcare proxy document, you're not unconscious or not in your right mind, they will encourage you to sign a healthcare proxy, because if something happens, they want to be able to turn to someone and say, well, we have to do this, but we need consent. The patient is unconscious or in a coma, and we need authority. In the absence of a healthcare proxy, the alternative is to go into the probate court to get a guardianship with authority to authorize or decline medical treatment. And a guardian, if the plan is to move the person from a hospital to a nursing home, the guardian has to get authority to do that, authority to admit the person to the nursing home. A durable power of attorney agent can authorize or decline any kind of treatment because they're basically the patient. But if you're a guardian appointed by the court, you have to go to the court in order to get treatment that's beyond the customary or usual medical treatment. And going into a nursing home is beyond the usual medical treatment. In fact, if you're in court, a guardian is trying to get authority to admit someone to a nursing home. The test isn't whether the patient would go into a nursing home. The test is whether it's in the best interest of the patient to go into a nursing home. That's the only exception to the rule. In every other case, the court's job is to try to determine what the patient would want if they were able to speak for himself or herself. Any questions about healthcare products? Next is durable power of attorney. A power of attorney is you give authority to someone else to act in your interest with respect to your income, your assets. It can be very specific. I authorize John to transfer the cottage I own in New Hampshire to a suitable buyer, or it can be a general authority giving every possible power to the agent. My recommendation is that if your loved one doesn't have a power of attorney and has capacity to sign one, absolutely get it done. And I would say that if it's a case where the person owns real estate or has significant assets, I think my recommendation would be to consult with an elder law attorney. All the references, all the information to how you can contact an expert advisor is in the guide. Any questions about powers of attorney? Last will and testament, everybody knows what that is. And it's important to have one because with a last will and testament, you control how your estate is distributed, who are the beneficiaries of the estate after your passing. Yes.
This goes back to power of attorney. If someone passes away, the power of attorney is no longer effective. But what if they don't have any family and you want to arrange their burial and stuff like that? Are you still able to do it? Because there was one case happened to a friend of mine in Chicago. This man died, no relatives, and a friend wanted to bury him, but he couldn't because there was some distant relative they had to get permission from, and it was almost, it was very difficult.
So good question. A durable power of attorney ceases to have any effect when the principal dies. So when a person dies, it's always struck me as kind of ironic, but the remains become the personal property of the next of kin. So if you die and you have a cousin who lives in Wyoming, your cousin in Wyoming is the owner of your remains. It's personal property of the owner, of the cousin. Now, what you can do, you have to become you have to get authority to manage the estate of the deceased. So if there were assets that are worth less than $25,000, that's the definition of a small estate in Massachusetts, less than $25,000. You can file what's called a voluntary power of attorney. I'm sorry, a voluntary administrator, not a voluntary administration. And that is a petition that you file with the probate court that says so-and-so has died. Their estate is less than $25,000. I want authority to manage the estate. And once you're in that position, you would be able to take possession of the remains and provide a burial or a cremation or whatever it is that the deceased wished, assuming that you know
Yeah.
that.
If they're over, if they have assets, if
Right.
they have a house.
Or if they have a house, then there isn't a house in Massachusetts that's worth less than $25,000.
Right,
Even if
exactly.
if it's charred remains, it's worth more than $25,000.
Yeah,
So in that case, you would have to file, if the person who died had a last will and testament, you file a petition to probate the will. If they died without a will, they're said to have died intestate, which means without a will. And there is a statute that provides for how the estate of the deceased will be distributed. And it's based on kinship. It's probably in the book as well, there's a description of who benefits. The first column is, when you die with a spouse and children, and then you die without a spouse but children, with children but no spouse. And if you died and you had children from a first marriage or a second marriage, it gets very complicated. But basically, the statute controls who are your beneficiaries of your estate if you haven't had a last will and testament. So if that's not what you want, again, that's the third document that everybody should have.
yeah. So when can you bury your friend?
Well, once you have authority as whether you're the personal representative of an estate because there is a will or there is no will, but the court has appointed you, you have authority to do anything that's required.
Oh, okay.
Now, if the person was penniless and has nothing, you have the responsibility, I guess, to provide whatever as far as you can tell, whatever the decedent wanted to do. And it's all over the place now between a traditional funeral versus cremation versus something called human compost. You can actually sign an agreement or sign an instruction that you can basically become fertilizer. There's a whole lot of options that you have, but everybody should be clear. Certainly at my age, you should be clear. You should make it clear to your loved ones what your wishes are. Guardianship or conservatorship, we talked a little bit about that. So if the person you're caring for has all three documents, that's the first thing you want to accomplish. And because, as I said, if you don't have a healthcare proxy document in place, then it will be necessary for you to file for a guardianship in the probate court to get authority to do whatever kind of medical care is being recommended, treatment is being recommended by the doctor or the medical people who are taking care of your principal. If the person has income and assets, the guardian's authority is very limited, and you probably have to file a conservatorship petition in order to manage income and assets. Any kind of an asset would require a conservatorship. If somebody owns real estate, if they have significant assets, and in that case, I would say, if the person has assets, bank accounts, liquid assets over $5,000, you probably would require a conservator, unless your loved one has put people's names as joint owners of bank accounts. That's another way to avoid guardianship or conservatorship if the principal has added to someone's name a joint owner of a bank account, a joint owner of real estate, or a beneficiary for cases for assets that call for a beneficiary, like an IRA or any kind of brokerage house account, anything that you can you can either name a joint owner or a beneficiary at your death. So that the ownership of the asset will pass to either a surviving joint owner or to a beneficiary named in an asset that where there isn't a joint owner, but there is a beneficiary. Just a word about estate tax, the taxable estate. Most of us don't have to worry about it. In order for an estate to be taxable under the federal law, I think it's about 12 or $15 million. Anybody?
Not yet.
Massachusetts is $2 million. Now, Massachusetts is something to consider because $2 million, if you own property, you know, you might have the better part of $1 million just by virtue of owning real estate. So, but just make a note that if it looks like you have, if you were to die today and your assets are worth more than $2 million, you want to make some plans about making gifts or whatever in order to avoid an estate tax, either to the feds or to the feds. We already said nobody's worried about that, but the state is a much lower amount.
Give me a description, define guardianship and conservatorship. What's the difference?
So a guardian is responsible for your medical treatment, where you're going to live, manage everything except finances.
Oh,
Now, the guardian can handle a small amount of finances. For instance, if the principal only has Social Security income,
right.
you can become representative payee with Social Security, and there's no need to do a conservatorship. But if the person has significant assets, or if they have income where there is no representative payee mechanism, and as far as I can tell, if you're a state retiree, there is no representative payee mechanism. You can't become a representative payee for someone who's a state pensioner, state or local pensioner. So you probably would have to do a conservatorship. Did I see a hand? No?
No.
Okay.
So is guardianship just financial or all decisions?
Conservatorship is just financial.
But guardianship is all.
It's everything else, yeah. It's managing the affairs, where the person's going to live. If they're going to go into a nursing home.
It's just with or without their consent.
Well, once a guardian is appointed, that person has authority to do whatever the court has approved. Now, a guardian, court-appointed guardian has a duty to consult with the person that they're guardian for, and they're supposed to defer to those wishes. They really are not encouraged to do anything that the principal doesn't want. It's called the incapacitated person, the IP. So they're supposed to consult with the IP, but IPs can be delusional and just not aware of. They may be expressing wishes that are just not practical or not feasible or whatever. So, but there is definitely when a guardian is appointed, they are supposed to consult with the incapacitated person and carry out that person's wishes and values as best they can. Yes.
Conservatorship, is it just finances or is it medical too? So is guardianship just medical and conservatorship just financial?
Conservator is just financial.
So how would you do both?
You have to be appointed guardian in one petition and a guardian in a conservator in one, guardian in another. So you'll get a decree appointing you conservator, so you can manage income and assets. And you have another decree appointing you guardian, so you can manage all the other
And what if
aspects.
it's challenged?
What's that?
What if it's challenged?
Well, if it's challenged, then there'll be a hearing, and the court will the judge will listen to the evidence from both sides and decide whether when you file a petition for a guardianship or a conservatorship, you nominate somebody to serve in that capacity. So a contest would arise if there's somebody who's objecting to that person being serving as guardian or as conservator. And if there's an objection, the court can appoint a temporary guardian or conservator for 90 days. If there's something has to be addressed immediately. And if there's an objection, there'll be a hearing by the court to listen to what the objection is and to decide whether the objection is serious enough to warrant a different guardian or conservator to serve.
And I was told both of the processes. take
I'm sorry, you have to
12
speak up a little.
I was told the processes, both of them, take 8 to 12 months.
If they what?
They take to get it in place, I guess.
Can they take 8 to 12 months? Is it that long?
No, it won't take 8 to 12 months, but it will take time. A temporary, you can file a petition for appointment of a guardian and ask for a temporary guardian to be appointed because there's an emergency. Something has to be dealt with right away. And the court will listen to the petitioner, will listen to anybody who's the petitioner has to give notice to the next of kin of the person who is in need of a guardian. So the next of kin, when the motion for appointment of a temporary guardian, which is appointment for 90 days, the motion to appoint a temporary guardian has to be delivered to the next of kin. And there'll be a hearing before the judge where the person presenting the motion explains why temporary guardian is needed. Anybody who has anything to say about it, either for or against, has an opportunity to do so. And then the court will either appoint the nominated temporary guardian or somebody else, or will just deny the motion. Everything depends on the evidence in the case. And I should say that a major problem in the area of guardianship is that there is no mechanism in Massachusetts if somebody needs a guardian and nobody is available to serve. Remember I said when you file a petition, you have to nominate somebody to serve as a guardian. And if there is nobody, you cannot identify anybody willing to step forward and act as guardian. The court does not have authority to appoint somebody because the court cannot pay for the guardian. If the person who needs a guardian has assets, the court may ask an attorney to serve as temporary guardian or temporary conservator and expect to be paid from the estate of the individual. But if they don't have assets, then the court will basically say after a hearing, okay, I have heard the case, I've heard the evidence, this person needs a guardian. You haven't nominated anybody. I don't have anyone that I can appoint as guardian. So come back to me when you have somebody willing to serve. And if they're a suitable person, I will appoint them. That's in most states, 35 or more, there's something called a public guardian. So the court can say, I'm going to refer this case to the public guardian, and they will step in and serve as guardian. But Massachusetts does not have a public guardian. So until we get an agency that can step in, that the court can say, okay, you haven't nominated a guardian, but I'm going to refer this matter to the public guardian. Until that day comes, you're just out of luck. And in fact, on any given day in Massachusetts, according to the Hospital Association, there are about 2,000 people who are stuck in hospitals who can't get out of the hospital into a nursing home for lack of a guardian. There's no guardian available to arrange for the discharge from the hospital and the admission to the nursing home. And the other obstacle is insurance, whether there's a problem with the nursing home they want to be sure they're going to get paid. They're not going to admit anybody if they're going to get stuck with the bill. So you have to show that there's a source of payment before a nursing home will admit. Most of the time, the problem is with Mass Health, Medicaid, not private insurance, because private insurance doesn't cover a lot of nursing home care. Medicare has very limited nursing home coverage. If you go from a hospital to a nursing home after you've been in the hospital for 3 days, and you go to the nursing home and you're going to need daily skilled nursing care, you might get some coverage, maybe up to 20 days, and a co-insurance up to 80 days. But nobody should think that Medicare is going to cover a nursing home placement that's going to last a long time. So we're going to talk about Mass Health because I think that your loved one, if you're providing care and you anticipate that that as person's condition deteriorates, they need more and more care. The question becomes: can you get help from you? Can you get help providing the care, or does the person need to go into a long-term care facility? So we're talking about about that requirement. If you anticipate a nursing home placement, either in the short run or in the long run, and you are the spouse caregiver, you definitely want to talk to an elder law attorney, because there are protections for a spouse in terms of the financial cost of a nursing home placement. And again, that's all covered in the guide, but there are protections for a community spouse when the other spouse is in a nursing home. And if you're a child caregiver, if you're an adult child providing care, you want to consult with an ASAP like HBAM to talk about the PACE program or something called a SCO, a Senior Care Organization, which is an insurance plan that will if your loved one is Medicare and Medicaid eligible, they can join the PACE or the SCO program, and there are no premiums to be paid. That program will make a care plan, what the person needs in terms of support while they're in the community. And the whole idea of a PACE and SCO is to keep you at home and not in a nursing home. If the condition deteriorates so that a nursing home placement is unavoidable, then they can arrange for a nursing home admission. But you have to be mindful of the financial aspects of that will be required if you do anticipate somebody going into nursing. Now, I've thrown out a lot of information. Any questions about what I've said so far? Yes.
So if that was the case and someone went to the wrong home, just.
Yeah, so if the loved one owns his or her own home, then and the caregiver is a spouse, again, I'm not going to give advice. I'm going to tell you to consult with expert legal counselor. But the general rule is to consider transferring title to the house. If it's jointly owned by both spouses, to transfer title to the house to the caregiver spouse, so that it's not going to be vulnerable to Mass Health costs. See, if you're in a nursing home and you're Mass Health eligible, then the first thing you need to know is that if you die and you have assets in your estate, Medicaid has a lien, a claim against your estate. And basically, they can recover the cost of nursing home care. So if somebody goes into a nursing home, let's say it's a husband and wife arrangement. Husband goes into a nursing home, they don't make any plans. And the wife is the first to die. The house goes into the husband's estate and it's subject to a claim by Mass Health when he dies and the house goes into his estate. And the claim is usually somewhere between $200 and $300 a day. So the private pay rate now is usually 500 something a day. The private pay rate, well, ones I have seen recently are in the $550 a day range. For that reason alone, you need to consult with an expert. If it's a caretaker child, and the person, the loved one is a parent, let's say a divorced or a widow or widower, if the caretaker child has lived in the house and taken care of the loved one for 2 years, basically to forestall a nursing home placement, then the parent can transfer the title to the house to the caretaker child without impacting Medicaid eligibility. And recently, the estate recovery folks have changed the rules. So now that even after the elder dies, if the house goes into the estate and a caretaker child can prove that the parent was a candidate for nursing home placement, the caretaker child lived in the home and took care of him and forestalled the nursing home placement for 2 years, they will waive the claim against the estate. So it's these kind of issues that is the reason why I'm urging everybody. You all have individual situations, individual cases, and you need to confer with an expert on the financial side. On the caretaker side, as I said, if you're able to get your loved one qualified for a PACE program or a SCO program, you get expert advice on the system, what is available from the system to provide the care necessary to keep the person at home. And as I said, the goal of those programs is to keep the person at home and out of the nursing home. So a geriatric care manager would be an expert on the system. If you're looking for an agency to provide personal care attendant or home health aid services, then a geriatric, or you need a placement, whether it's in a nursing home or a rest home or an assisted living residence. The geriatric care manager can give you expert advice on the care side. So you got the care issues and you got the financial, and you really need to understand this. This was a good introduction, but as I said, it's only educational. You need to get advice that's specific to your situation. Yes.
My question is, if parent owns their own home, and it's just one parent, and they need money for caregivers, which is super expensive. What's your feeling on an equity loan or something like that?
On an equity loan?
Something like that. They've had reverse mortgages, their house is paid for. We've looked into some reverse mortgages and they kind of scale. It's not. But how can they get on the base of choose some money?
Well, again, I'm going to say, if you have a situation where the person owns real estate, you need to consult with an expert to give you the options. What options are there? Paying for a personal care attendant or home health aides is very expensive. And in fact, if your loved one is in the PACE or the SCO program, they will even pay a live-in child who's a caregiver. They will pay them a stipend. It's not wages, it's a stipend. I think it's $1,200 a month or $1,500, something like that. Does somebody know?
There's a lot of stipulations.
Yeah, but this is a fixed amount.
I think it's 15.
What's that?
I think it's 15.
1,500?
I think so.
It's either 12 or 1,500, but it's not taxable income. And it will help defray costs. Sometimes a caregiver has to give up her job in order to move in and care for the parent. So that's something to keep. That's another advantage of joining the PACE or a SCO program. Now, in order to be eligible to join a PACE or a SCO program, remember I said you have to be Mass Health eligible. So there is a way where you can join PACE without joining Mass Health, but that's something that you would have to talk to an expert on, where there's a very hefty premium that gets paid. Usually, if you're on PACE or SCO, you don't pay a monthly premium. Yes. Did I see a hand?
I did. So I called for that, if I may, and you can only have 2,000 per husband and wife in the bank, and you can still own a home, but you would pay like 30% a month
30%
of your income a month to PACE for help.
to pay for PACE?
Yeah,
Of that 2,000?
no, you can only have 2,000 in the bank per person, so my husband can get it, I can get it, even though you own a house.
Yes.
But they do take 25 or 30% to come out for services. Like my husband broke his leg.
$2,000.
My husband broke his leg and they wanted 25% to come in and wash him and do his clothes and laundry and stuff like that.
Was he actually on the PACE program, or was this just something?
No, we were gonna get it.
I'm not sure that that's how it works. I think that in order to join the PACE program, I don't know if it's available to a SCO program, but in the PACE program, if you're not eligible for Mass Health, but you are Medicare, then there's a way that you can join the PACE program. But I think it requires a pretty hefty monthly premium.
Yeah, that's what I was saying. It's 25 or 30%.
Yeah, I don't know. The 25 or 30% is what I'm not sure about. That's all I'm saying is that I don't want anybody to think we're giving legal advice here. So I would just say that if that's an issue. Now,
Just something to look into.
in terms of a personal care attendant, if your loved one needs a personal care attendant, first of all, you could potentially be a personal care attendant, and you get paid. I think it's
I
like,
think it might be 12. I think you're right. I think it's 12.
I'm sorry, I can't hear you.
I think you're right. My daughter's doing. I think it's 12.
It's $1,200 if it's a stipend,
Yes.
but if you're a personal care attendant, you get paid wages.
Oh, yes.
The principal hires a personal care attendant. And if it's a live-in personal care attendant, this is a new development that I just learned in the last couple of weeks. If you're a live-in personal care attendant and you were paid, you get paid salary, and like any other employee, there are deductions for federal and state withholding taxes. But Governor Healy announced that for last year, 2025 and 2026, a live-in personal care attendant's wages are not taxable. So people who were live-in personal care attendants the last year are going to get a windfall because all of the withholding will be reimbursed when they file their income tax return.
So the PCAs cannot be relatives.
A PCA, can be a relative.
Yeah.
They can't, I don't think they can be a spouse.
Spouse.
I could be with my mom.
Okay.
Yeah, I think the only limitation is that a spouse cannot be a PCA. But a child can certainly be, or any other person except a spouse.
Yeah.
So that, we're just talking about the Frail Elder Waiver Program is a way to join a plan. And as long as the person is a candidate for a nursing home placement, they can be in the Frail Elder Waiver Program on Mass Health, and Mass Health will pay for the services being provided. Now, if the person has a spouse, then the spouse's assets count. When you sign up for Mass Health and you're married, Mass Health looks at the assets of both spouses. And this is important. If one spouse is in a nursing home, they look at the assets of both spouses, whether it's asset is in just the wife's name, just in the husband's name, or in both names, or in one name with a cousin or a brother or a child. They add them all up. And the nursing home spouse is allowed to have $2,000 in liquid assets. And the community spouse is allowed to have about $162,000 in liquid assets. But if they have more than that, they have to do something with the excess assets. And there are ways to deal with it. Basically, one way to deal with it is if the community spouse has, let's say, $400,000 in liquid assets, they can take the amount that's over $162,000 and buy an annuity, single premium immediate annuity, which basically converts excess assets into non-countable assets, increases the income to the community spouse, and the person and the nursing home spouse becomes eligible once the annuity is purchased. There's also if the person is a single person and has excess assets, there is an option called a pooled trust. I don't know if that's on the is that on this thing or not? A pooled trust is a planning mechanism where you can take excess assets and open up a pooled trust account. And a pooled trust is basically a plan. And there are two major ones in Massachusetts, Guardian Community Trust in Andover, and the Plan of Mass in Rhode Island in Boston. Basically, here's how it works. Let's say someone's in a nursing home, they're on Mass Health, so they get less than $2,000 in countable assets, and they inherit $50,000. What are their options? One is they can basically pay the nursing home $15,000 a month until the $50,000 is gone. What's that, 3.5 months? Or they can put the money into a pooled trust account. Now, a pooled trust, basically, they put the $50,000 into the pooled trust. Pooled trust becomes the trustee of the money, and the pooled trust will pay for any kind of service or goods that Mass Health will not pay for. So if you're interested in a pooled trust and how it works, go to the website of either Guardian Community Trust or Plan of Mass in Rhode Island, and they'll explain what the benefits are of operating a pooled trust. Now, you may ask, why does Mass Health allow this? And it's because when the person dies, if there's residue left in the pooled trust account, Mass Health shows up to get it first. And if there's anything, if Mass Health gets reimbursed for whatever they paid for nursing home costs, if there's anything left over, it will go to the beneficiary that's named in the money account. This, again, all I'm saying is, you've got an individual situation, get expert advice that's focused on your situation. Yes.
Can you do that if you're on, regular Medicare, or is that just if you're on Mass Health, that full trust account?
Well, in order to open a pool trust, you have to be disabled. So if you're on Social Security and it's retirement versus disability, you're not eligible for a pool trust, and they'll tell you that.
Do they have a list of disabilities?
What?
Do they have a list of the disabilities?
Disability is defined by Social Security as a diagnosed medical condition that interferes with your ability to basically engage in substantial gainful employment. And it's actually, there's a figure that is used if you're disabled, but you're working and you earn more than a certain amount, let's say $1,200 a month, something like that, you're not eligible. But if you,
Cognition or something.
I'm sorry.
Cognition disability.
Well, if you're cognitively impaired, it's just one disability. I mean, you may have bad back, there's all kinds of.
No, I know there's other kinds.
All right, well, I'm trying to answer your question. When you said, is there a list of disability?
Yeah, and I just blurted it out.
Right. Well, but it was a good question. I mean, I think that the definition is not, how many medical conditions is psychiatric.
Well, I'm sure there's tons.
Yes, but so the definition,
Qualify for SSI, right?
well, the SSI is different from Social Security.
Yeah.
Social Security, if you're disabled, if you have a medical determined disability that interferes with your ability to basically hold down a full-time job, you can get Social Security disability. SSI has the additional requirement of need. It's based on need. So if you have Social Security income, let's say of $800 a month, and you qualify for SSI, which are the same rules as Medicaid, you have to have less than $2,000 in liquid assets. Then you qualify for SSI, you may be entitled to get additional income from the SSI program. But it is definitely a needs program, so it's available to it's the so-called safety net program. So it's designed for low-income folks.
So the full trust account's basically for people that are.
Well, a pool trust, as I said, your options, I use this as an example, a nursing home resident who gets a $50,000 inheritance. The options are you go off Medicaid and pay privately until the $50,000 is spent, which won't take long, or you open up a pool trust account. Yes.
Now, these pool trusts, they're basically annuity, correct?
No,
No.
anything but. An annuity will pay a monthly income. If a community spouse buys an annuity, what's in,
Separate from the trust.
well, I'll explain the difference. The annuity, you put in $100,000 with John Hancock, and they pay you $500 a month. Okay, that's a single immediate annuity. Full trust, you put your money in, and you only get distributions when you ask for it. I think this is worth a little anecdote. I had a client who went into the sold his home. He was in a nursing home, put money into the pool trust, and when he died, I asked the son what was the experience with the pool trust, and he said they paid for a visiting dog to come in and visit his father. And he said that he looked forward to the dog's visit more than my sister and I. So that's the kind of thing. I mean, it's basically a quality of life. Remember, if you're on Mass Health in a nursing home, your income that you can keep is only $72.80. Imagine an annual income of less than $900 a month. That's the situation that people who are in nursing homes on Mass Health are. And if you get that money, I think it's just common sense to put it into a pool trust because then you can get quality if you wanna go to your granddaughter's wedding in Philadelphia, that sort of thing. You know, you can ask the pool trust for a distribution to allow you to do that. So it really is it's a quality of life issue when somebody has, imagine living on $900 a year. They provide room and board, you know, they feed you and so on. But again, I sound like a broken record, but you definitely want to make sure that you understand your options and your loved one's options. Okay, so when you apply, when a nursing home resident applies for Mass Health, they have to show that they have countable assets of less than 2,000. And as I said, if there's a community spouse, their combined assets have to be less than roughly $164,000. They have to show that they're clinically eligible for Medicaid reimbursement, and that is that they require assistance with three activities of daily living: getting in and out of bed, going to the bathroom, feeding, dressing, and if they have some cognitive impairment. Cognitive impairment is, in my view, the major reason why most folks are in nursing homes, because they lack safety capacity. They don't really know what they should do if the building is on fire, that sort of thing. So you have to show that you're financially eligible, that you're clinically eligible, and you have to show that you didn't, the 5-year look back period. You have to show that in the prior 5 years, you didn't make any gifts or transfers that would disqualify you because you did it in order to qualify for Medicaid. Now, let me ask, have any of you ever dealt with Mass Health at any level or any degree? Okay. You probably know how difficult they are to deal with. I will tell you, if you don't know, they're difficult to deal with. And they oftentimes act, even though there's a regulation that says the work is supposed to assist an applicant, they do anything but assist. They sometimes see themselves as an obstacle course that you have to run in order to be eligible for Mass Health. So if you have to apply for Mass Health, again, in my view, sometimes the nursing home will offer to do the application. Probably not a good idea. You should consult with an expert. Elder law attorney may not want to actually handle an application because they're very time consuming, and no lawyer wants to charge, $300 or $400 an hour for something that could be very time consuming. So, but you can get assistance with the application. So if that situation arises, as I said, don't go it alone. Get the proper expert advice. How are we doing for time? 1:30. And what time are we until 2? 2. I already talked about annuity. I guess what's the next? Yeah, let's talk about assisted living residences. When I started practice in 1972, there were no assisted living residences. There were nursing homes. And nursing homes complained about how little Medicaid paid, Mass Health paid, and sort of lived on people who could afford to move in and pay privately for a period of time. But along came the assisted living residence industry, probably, I'm going to say maybe in the 80s or the 90s. And an assisted living resident is basically a very expensive alternative to a nursing home. If you moved your loved one into an assisted living residence, the average monthly expense is between 5,000 and 17,000. Now, I just said the average for a private pay in a nursing home is 15,000, but there are the state ALR ombudsman reports that that's the range that ALRs pay. Because Medicaid and at Mass Health does not pay for assisted living residents. The assisted living resident should tell you, okay, you're gonna move in, it's gonna cost you $6,000 a month. We're gonna provide you with meals and some services and so on. But when your savings run out, there's the door. They will evict you if your medical condition worsens, physical or mental, where they can no longer provide the services that you require. Then also grounds for being discharged. Now, for assisted living residents, generally speaking, landlord-tenant law applies. So if the assisted living resident says time for you to move and you don't move, they have to go through the judicial process, summary process eviction proceeding, where they actually go into court and say, we have to evict this person because they're not paying the rent. The rent is $6,000 and they haven't paid it. And non-payment grounds for an eviction under landlord-tenant. I'm no fan of ALRs, and we've had cases where they misrepresented the affordability issue, and one is a case that arose in Danvers, actually. I won't name the ALR, although I don't know the ALRs that are in Danvers, but this couple sold their home and they were told, if you move in here, we have this nifty thing called the low income tax credit program. So basically when your savings run out, you'll be able to stay because it'll be affordable under the low income tax credit program. So I got involved when the husband had died and they were evicting the wife, the widow. What happened was, when they moved in, they said what I just told you. But when they applied for the low income only tax credit, the low income tax credit, housing tax credit, they were not eligible because their income, if they were eligible for the program, the rent would still be about 90% of their income. Usually, if you think of a subsidized housing, mostly Section 8, public housing, the basic rule is a tenant pays 30% of their income. So for rent, so the couple that I represented just assumed that that when they ran out of savings, they would only have to pay 30% of their income for the rental part of the monthly charges, but it wasn't 30%, it was a whole lot more. So there are now, the Attorney General is developing consumer protection regulations for assisted living rents that will address issues like that. So that most people in ALRs are very happy where they are. They have no complaints about the services and so on, with the environment. They're happy as little clams. But when things go south, they can be very, very bad. Now, CCRCs, continuing care retirement communities, the rich cousin of assisted living residents. There's Brooksby Village, and that's a Danvers. So is it Peabody or Danvers? If you're going to move into a community care retirement community, you have to pony up an entrance fee that ranges from 300,000 to $1 million or $1 million plus. Most people who move in they sell their home, and that's how they pay the entrance fee. They have to pay a monthly charge, and Brooksby Village, to its credit, does have the full continuum of care. So they tell you when you move in, this is where you'll live for the rest of your life. You're in independent living. If your condition changes and you need help, you can move into the supported living component. And if you need nursing home care, you move into the long-term care unit. And you're covered, you don't have to move. Now, we've had problems, but basically, issues arise when somebody says, you know, I don't really like it here. I want to move out. And I'm gonna move out next month, and where's my 500,000? And the CCRC, now I'm not picking on Brooksby Village now, I'm saying generally speaking, the CCRC says, well, we'll give you your 500,000 when someone else moves in and pays the 500,000, we'll pay you. Now that sounds to me like a Ponzi scheme, if you've ever heard of it. But that's how it works. And you can, there are contracts when you move in where they say, we're gonna refund your, when you move out or when you pass away, we will refund the entrance deposit to you or to your estate, but they don't say how long it takes. And it can take 90 days and it can take forever. Last year, the legislature created a CCRC commission. And the CCRC commission came out with two recommendations. One is that the age, we used to be the Executive Office of Elder Affairs, is now Office of Aging and Independence. They publish a guide for CCRC residents. So the vote was to upgrade the guide. The second was to approve or to recommend the approval of a bill that's in front of the legislature called the CCRC Disclosure Bill, where when you're moving into a CCRC, they tell you with a written document that you sign and the CCRC signs that says, here's what happens with your entrance fee. You get it all back. You lose 1% a month. It reduces down to half its value, so on. But you know what you're going to get when you move out. If it's honest, what we'll say now is we have to refund your money, but there's no time limit on when we have to refund you. So I don't know that any of your loved ones are candidates for CCRC. As I said, they're the rich cousin of ALRs, but I did want to let you know that is at least an option in the scheme of things.
Is their monthly fee expensive for the CCRC?
Is what?
The monthly fee? You put down that big deposit to like hold your spot, but the monthly fee must be.
So if you're in the independent living, it may be $2,000 or $3,000 a month. All they're doing is providing you with meals and services. I mean, again, like ALR residents, the CCRC residents are happy with their arrangement. It's not like it's an awful situation. If you move from independent living to supported living, the price goes up, and it's probably in the $10,000 to $12,000 range. And then if you go into the long-term care, if they don't have a contract with Mass Health, it's $15,000 a month. Now, Brooksby Village, as a matter of fact, I know from experience, does have I think 16 beds that are Mass Health certified. So if you do go into the long-term care component at Brooksby Village, you can become eligible for Mass Health. If you're an individual, you have to spend down the entrance fee. So, and you become eligible for Mass Health in the long-term care component, when your entrance fee deposit has gone down to below 2,000.
And is it true that their nursing home is not Medicare or Medicaid?
Well,
And it is a DD.
I know that Brooksby Village has, and their sister, Linden
Linda
Ponds,
Pond,
they have, Medicare, Medicaid certified beds.
they do.
So
Not many.
you're supposed to go, as your condition worsens, independent supported, long-term care. Now, if you're a married person and you're in long-term care, Medicaid should protect $162,000 of the well spouse, the healthy spouse. So, that can get a little dicey. But basically speaking, the community spouse is protected to the extent of $162,000, and the entrance deposit is not a countable asset. But if they have a lot of other assets besides the entrance deposit, the community spouse has to spend down to $162,000, or what? Buy an annuity, or if she's disabled, under pool trust.
John, are the annuities only for spouses?
I'm sorry?
Are the annuities only for spouses, or could they be for a domestic partner?
Oh, only a spouse. Same-sex couples are protected, but not domestic partners. There has to be a marriage.
Children?
You can transfer a house to a disabled child. Disabled, blind, minor, or a caretaker child. But if a single person can buy an annuity, and the annuity has to provide that if there's a residue, it goes to Mass Health. If Mass Health is owed, the estate recovery is looking for reimbursement, they get paid first, just as with the pool trust account. An annuity fund, if you put $50,000 into an annuity and it's paying you, $200 a month, when you die, you name the beneficiary in the annuity, but the annuity contract provides that Mass Health gets paid first. Again, none of this is legal advice. All of you you have individual situations and you need to get individualized advice. All right, so Q&A, I think we're Q&A, yeah. On Q. Anything I didn't cover that you came with a question about and didn't get answered?
No, you did a very good job. Thank you very much.
Well, you can see that these, if you get one of these, you'll see the value of it. There are some there, so if you leave without one, as I said, you can go on Google and just put in the title, 2025 Elder Law Education Guide, Mass Bar Association, and you can download the whole shebang.
I just want to plug two things before, as John wraps up. We have example durable power of attorney and healthcare proxy documents, if you want them. And the other thing that I'd like to say is we're from Northeast Legal Aid, and we've recently started a Medicare appeals program. And so what this means, if you or a loved one is on Medicare, and they receive, some kind of notice saying that like their care might not be covered, or they're like terminating certain benefits, you should follow the appeal instructions on that notice. You can always do it immediately, and it's highly recommended that you always appeal. Most people will say just do the initial appeal first because it's very easy to do on your own. But if you get repeatedly denied for the same thing and it's getting to the point where, like it seems medically necessary or seems like you could use the benefit of an attorney, I would definitely recommend where Northeast Legal Aid is taking these types of appeal cases. And so you can call our mainline intake number and we'll hopefully be able to see if there's anything we can do in the case of that Medicare appeal.
Thank you.
Yep, here, I can,
The whole packet. but
yeah.
it's okay.
The bulk,
Oh, there's
yep.
no packet.
Sorry, I just.
Look, this one
You
here,
kept it quick.
like,
You know what those,
It's just an example, we'll see if you want to compare it to other examples. Yeah, it's just an example to look at.
But it doesn't work. So you don't.
I want-
No, no age. Healthy enough that you don't need, you don't need guardian.
No, he doesn't, he lives independently.
Yeah.
Near me, but I don't know how, but it's related to moving and housekeeping and stuff like that.
Than anybody. I was at a meeting where the fellow was presenting, said, how many residents how many of you married? You people have been in assisted living.
Yeah, all right.
I'll make a motion to adjourn. Thank you all.
Thank you, you're so knowledgeable, it's amazing, you guys are the best, we'll have to do one more too. Before the end of September.
Other examples of
Tell me when you go to you.
Well, what, I guess we get subject.
it would be the same one, it's the same thing, just in the Merrimack Valley, the same.
Oh,
One in North Shore, one in Merrimack.
and use, you can't use this twice.
I can post this, but we have to.